Guys, sit down, grab a hold of your seats, and prepare to be pissed. Got a bad ruling that popped out on these bad Larrys, and it's not good, and you should be fired up, and you're going to want to know about this. First off, welcome back to Guns and Gadgets, your premier source for Second Amendment news. And if you believe in protecting our rights, including these metal tubes with wavy things in them, then stay informed, hit that subscribe button down below, and turn on all notifications. It helps us here on this channel fight back against the censorship of our Pro 2A content by the powers that be. We'll just leave it like that. Now, today, I'm covering a major ruling out of what is usually the best circuit in the country when it comes to Second Amendment cases. I'm speaking about the Fifth Circuit Court of Appeals. And this decision is one that every gun owner needs to be aware of and hear today. So I'm asking you to like the video and share it so people see it. A man named George Peterson was convicted for possessing an unregistered suppressor, and he challenged those laws on Second and Fourth Amendment grounds. Now, the court just issued its ruling yesterday evening, and let's just say it's raising some serious concerns about how our rights are being interpreted, especially now in the Fifth Circuit. Now, this could just be a bump in the road. It's a 3-judge panel. It's not the end of the road. There's still a potential en banc review, and then maybe certiorari seeking in the Supreme Court. So it's not the end-all be-all, but right now, this is no bueno. First, do you remember when there was an ammo shortage in 2020? All the store shelves were empty, and there was nothing online. There's a company in Idaho that lets you stockpile ammunition automatically so you have it when you need it. It's called Ammo Squared, and they've been around since 2015. You can sign up, pick a caliber. There's well over 70 different calibers to choose from. Set an auto-buy budget and select your shipping trigger. It accumulates over time and is stored for free until you want it. If you have a small budget, you can buy just a little bit at a time and let it build up. There's no minimum and no extra fees. Ammo is stored in a climate-controlled warehouse, which is important. You don't even have to request that. It's just part of the deal. And no other company does that. And when you want it, get it all shipped out within 2 business days. You can auto-buy it, ammunition. You can store it for free until you need it and get it shipped on your schedule. It takes all of the work out of buying ammo, and you can join the other 40,000 plus customers who have been satisfied. You know where to find them. Tell them that I sent you. All right, let's jump into this one, guys. Hold on to your hats, because this is a terrible ruling about suppressors. I'm going to try to put them down the right way now so they don't roll off my bar here. Let's start with the basics. George Peterson ran a small firearms business. It's called PDW Solutions, LLC, and he ran it right out of his home. But the ATF had been watching him for months. They sent in undercover agents and eventually got a search warrant for his home and his business. Check it out here. In the summer of 2022, federal and state law enforcement officers executed a warrant at PDW Solutions, LLC, Peterson's firearm business that he operated out of his home. An Eastern District of Louisiana magistrate judge issued that warrant based on an affidavit submitted by the Bureau of Alcohol, Tobacco, Firearms, and Explosives. Now, according to the ATF agent, the ATF had spent several months investigating Peterson before seeking the warrant. In one instance, the ATF sent a Jefferson Parish Sheriff's Office deputy into PDW to purchase 2 handguns. Peterson sold the officer the guns, but he did not report the transaction to the ATF despite 27 CFR section 478.126A's requirement that he must. That's if you buy 2 handguns or more, it has to be reported to the ATF if it's on the same transaction. In another instance, an undercover ATF agent patronized PDW with a confidential informant. Even though Peterson was aware that the informant could not lawfully purchase a firearm, he nevertheless sold the agent 2 firearms after watching the informant hand the agent the money for the purchase. So that's a straw purchase. And Peterson failed to report this transaction as well. And because all of this occurred at Peterson's home, the ATF believed that Peterson had also violated 18 U.S.C. section 1001 alpha 3 by representing in his federal firearms license application that he would conduct business only at gun shows and out of a leased storage unit. So he was running his FFL out of his home, and that's not his place of business. It's a big, big no-no. In light of this information, the magistrate judge issued a warrant authorizing a search of Peterson's home, where the ATF alleged he stored his inventory, and of another structure attached to his home where it alleged he conducted business. The warrant also authorized seizure of PDW's transactional and financial records, proceeds from firearm sales, firearms themselves, and computers and other digital devices, among other things. The ATF executed the warrant the next day. During the search, ATF agents discovered a firearm suppressor inside Peterson's bedroom closet safe. Interestingly, Peterson did not purchase this suppressor from a manufacturer. He acquired materials and a kit to make it himself. The suppressor was in working condition, but it neither had a serial number nor was it registered in the National Firearms Registration and Transfer Record. So they're alleging he violated the NFA by not filling out a Form 1 requesting from the overlords at ATF the permission to exercise his right and make the suppressor. Now, this all took place and Peterson fought back. He filed two key motions. The first was a motion to dismiss, arguing that the NFA's suppressor registration requirement violates the Second Amendment. Yeah, it does. The second was a motion to suppress evidence claiming the ATF search warrant violated his Fourth Amendment rights. So the way I'm just going to kill it by this part here. When an officer, in this case the agent from the ATF, fills out a search warrant affidavit, it goes to the judge. Here in this case it was a magistrate judge. The magistrate judge was supposed to read this and determine if there's probable cause and then sign off on it. When that judge signs off on it, all of the onus of that having probable cause falls on the judge. And Peterson's saying that in his opinion, the warrant application didn't have probable cause, and that's why he's trying to get it tossed out there. But we're going to focus here on the suppressor. We're going to start with that big one. Does the Second Amendment protect suppressors? According to the court, no. They ruled that suppressors are not arms under the Second Amendment. The judge said that because a suppressor isn't a weapon by itself, it doesn't fall under the keep and bear arms protection. Now, the court cited past rulings like Miller and even argued that a suppressor is more of an accessory than a fundamental part of a firearm. In fact, the judges said that a firearm can fire in and of itself, but a suppressor cannot. Therefore, it's not a firearm. We'll get into that in a second. Some people right now are like, yeah, let's pump the brakes. Now, this is a very dangerous precedent. By this logic, couldn't the government now ban optics, magazines, or even certain types of ammunition by calling them accessories? Well, first, for the magazines and ammo, the answer should be no, because according to the Miller decision, they're an integral part that the firearm needs in order to operate. But optics? What do you think on that? Drop a comment below and let me know what you think of this. This is a huge blow, not just to Peterson, but to all gun owners. If law enforcement can raid your home with a weak-ass warrant and still use what they find against you, that's a huge problem for the Fourth Amendment, which is your right to be free from unreasonable searches and seizures. So what is the big question here? This ruling confirms that suppressors are not protected by the Second Amendment. That means laws banning or restricting them are more likely to hold up in court, including states that are in the fifth that they're, I guess you could just say they're legal in. I mean, they should be legal everywhere, right? Now, the ATF likes to argue in court that suppressors are firearms when it's convenient for them, of course. That way they continue their unconstitutional regulation of a metal tube with some wavy things in it and get their $200 tax stamp, of course. But in this court, they say that it's not a protected arm. You can't have it both ways. You can't have it both ways. Well, what is it, guys? You know, some folks, like I said, will say good. They shouldn't be regulated. I agree they shouldn't be regulated. However, the Second Amendment protection should extend to them. Because in that scenario, if they're unregulated and unprotected by the Second Amendment, states can ban them all willy-nilly and it'll hold up much easier. This case is a wake-up call, y'all. We need to keep fighting and protect our Second and Fourth Amendments. All the amendments. And let me know in the comments, do you think this court got it right? Maybe one of you do. Or did they miss the mark? Before you go, make sure to subscribe to Guns and Gadgets if you want to stay in the know on the Second Amendment. I'm bringing you the latest news, the latest court cases, and the latest information on the government's attempt to restrict our rights. And as an American gun owner, I hope that you think that's important. Hit that like button and share the video so more people see it. And look, like I said before, it's not the end of the road. I'm assuming that this will be appealed to the en banc. What is an en banc? People say it's, so this was a 3-judge panel. When you appeal something, it goes to the Federal Court of Appeals or even State Court of Appeals. Usually there's a panel, and it's 3 judges from all of the judges in that circuit. They choose 3 to sit on the panel, and they hear the case and they make a decision. And in this case, they struck out. They got it wrong. So your option then would be Peterson's camp, would be to appeal this to an en banc, which is a bigger panel of judges throughout that circuit, and they look at how that Third Circuit ruled and decide if they were correct or incorrect. And then if you still don't get an outcome that you're favorable to, you could then appeal it to the United States Supreme Court and then hope and pray that they take your case up. Guys, this is nothing more than a car muffler that you can use on a firearm, and it does not make you an assassin. It does not turn you into someone who can shoot rounds without any noise at all. That's Hollywood BS. It's crap. It just muffles the report of that shot so that it's safe for hearing levels. But most of you know that. But I just wanted to get that out there because some people say, well, what's all the fuss about? We don't need suppressors. And usually people who either don't have them or don't want them or in a state that bans them. We should fight for everybody's rights, whether or not we choose to use that right. Okay. So let me know what you guys and gals think down below. I'm pissed. They got it wrong. This is a piss poor ruling. It needs to be fought. It needs to be appealed so that it doesn't stand. Because as it stands, if it's left to stand, bad case law. Now, it's just the 5th. It's not nationwide. But believe me when I tell you that other anti-gun circuits are going like this right now. I'll see you on the next one. Take care.